Well, good afternoon, and thank you for coming to this seminar. My name is Keith Brown. I'm an attorney in Bucks County. I practice with the firm of Stuckert & Yates, and I've been there for 30 years now, which is an amazing record even to me. But I've been practicing in the area of estate planning, administration, real estate, and corporate law. And we are a general practice firm, but those are my areas of specialty. So I'm going to be talking about estate planning and especially document preparation today. I know some of you in just a few days will probably be involved in the clinic's preparation of documents. So I want to make sure we focus a lot on that, but we'll also do kind of a general overview. It's going to be informal, so I'm going to welcome questions. Feel free to just interrupt. I'm fine with that. If there's a point that I need to complete, I'll do that and then we'll get to your question. But otherwise, just chime right in. So our agenda for today is just do a little quick introduction. We'll talk about estate planning as a continuous process. We'll talk about creating flexibility in wills and powers of attorney, and those are the areas we're going to be focused on mostly today. We will talk about an ideal for estate planning. We'll talk about drafting documents online and some common planning mistakes that happen in the area of estate planning. There are all kinds of mistakes that people can make, and we'll try to touch on the big ones, but we'll kind of go back and forth on that as well. You may have some stories you want to share. What I'm going to talk about today is the estate drafting process, looking at the documents that are available online, which are part of the CLCP website resource. So let's take a look. Estate planning is a continuous process. It's something you do all your life, and as I just was expecting I would hear, and I did just hear, everybody here is probably just as qualified to present this. You probably are all aware that throughout your lifetime, things will change. There'll be circumstances that will require an adjustment to estate planning, and so we're going to talk a little bit about that as well today. So the first thing we'll do is talk about creating flexibility, revising documents as necessary, trying to build flexibility into the documents right from the start, talk about an ideal for estate planning, and then we'll talk about writing the script. So every good estate plan is built with flexibility, like a jellyfish can move through the water, and each document must be capable of flexing with all the changes in circumstances. For example, the creator of the document may become divorced or get married, or there may be a tax code change which affects many aspects of the estate plan, or there may be others who are involved in the process. They're beneficiaries of the will, or they're fiduciaries who are named in the document, and so we want to be able to flex with those changes. The best practice is to plan for today and to expect to plan again, okay? Estate planning is not a one-time thing, and I'm sure from what you've said from your own backgrounds, you've seen situations where people come in 2 or 3 years after they saw you and they ask, can I make a change to my will? Of course, I'll be glad to help you with that, right? And the reason is, there are many different reasons. We've already named a few. See if you can come up with a couple that you can think of, maybe from your experience, something like that. There you go. Reason somebody might change their will? Mm-hmm.
Well, maybe who they want as a guardian of their minor children has changed.
Mm-hmm. That's a big one. That's probably the one that causes people to change their wills most frequently, especially as their children get older. They realize, that's not the right person anymore. Okay, good. Other examples of reasons to change wills? Mm-hmm.
Let's say one of your children behaves financially irresponsibly.
Yes.
Let's say they get involved in drug use or something.
Right.
It's not that you don't love the child anymore because they've done these things. It's not like it's a form of punishment.
Right.
But you wouldn't want to become an enabler to someone who would abuse the funds.
Right. Good example. And so taking off on that example, many times people will try to anticipate when they put together their estate plan documents that possibility. They'll try to plan for the worst and hope for the best. And so we try to help people do that as they draft their documents. Okay, so let's brainstorm. What are some of the important pieces of information and components of a good estate plan? Anybody? We've already talked about a will, so a will is certainly a foundation for it. What are some other good, important pieces of a good estate plan? Yes, Vicki?
Well, when I was doing this for legal assistance in the Army, sometimes we would grapple about how we were going to identify these people. So we wanted to make sure the person could be found.
Okay.
And sometimes we put identifying information such as a date of birth or a partial social security number in the will, so it would be easy for whoever was administrating it to find that person.
Right. Good. Good. Having pieces of information so we can identify and find somebody. Good. Other important components you can think of from your own experience or things you've seen in documents? What do you think?
Who's your executor?
Okay. Choosing the executor and making sure that you have more than one, right, Bob? It's always important to have a backup plan. I always tell people, have two if you can, because you never know when that first backup is not going to be available. They might be deceased or living in China or whatever the situation might be. So that's part of the flexibility in the plan, is making sure you have sufficient fiduciaries. Sometimes it's hard for people to come up with a fiduciary name, and I always tell them, keep thinking. Eventually, they many times will be able to do that. Let's think about an ideal for estate planning, which is maximizing control of the provision and care for your beneficiaries. You see this verse from Proverbs 13:22 says it very well. A good man leaves an inheritance for his children's children, but a sinner's wealth is stored up for the righteous. Okay, so controlling my property while I am well is part of this ideal for a good estate plan. Writing a script for my loved ones to follow so that they don't need to ad lib. And this is kind of a basic concept, but it does fit in very well with estate planning. Many of the things that lawyers do as they practice law is to advise people about what could go wrong. And so they try to think through what are the possible scenarios of a child going wrong, or maybe a child going through a divorce, all those kinds of things. Rather than having to ad lib and guess at what the person wanted, we have to make sure that there's something clearly in writing, has sufficient detail to indicate what their intentions are. And then going on, caring for myself and my loved ones if I become disabled or if I'm unable to think clearly. So now we're alluding to the need for having a good power of attorney. In fact, I always recommend to clients that they consider, and I'm sure you do too, having a power of attorney that covers financial decision-making as well as a power of attorney that covers healthcare decisions. It frequently works well for clients to separate those two different roles, because many times they'll have different people in mind to serve in those two different types of capacities. So also, giving what I have to whom I want, when I want to give it, and in a way that I want to give it, and all at the lowest possible cost to me and those I love. And that cost aspect, of course, alludes to trying to make sure we save as much on the costs of passing to the next, to the beneficiary, typically to the next generation, making sure we minimize taxes as much as possible. And so we're going to talk about how to make that happen, and we'll talk about the different ways of writing the script so we don't have an ad lib performance. Okay, we think about estate planning as a bridge. The bridge can either be a fancy bridge that's put together well, structurally sound, or we can have one that's imposed by the government, and we're not sure that that's going to be the best plan. Usually it's not. I think I gave out to a couple people, and I'll give this out as well to other people. This is called A Last Will and Testament of Pauline Procrastinator. I can pass that back. There we go. And Pauline has a problem. I have a problem too. I don't have enough of these, so I'll just pass a few of them out. And let me just read to you briefly a couple of the provisions from Pauline's will, which is imposed by, in this case, the state of Illinois. She died in Anywhere Heights, Illinois. She said her spouse is Paul Procrastinator. She has 2 children, ages 6 and 4. And in the first article, because she didn't draft a will, she died intestate, she gives to her husband only half of her assets because the other half are going to her children to be divided equally among them regardless of any special needs that they may have. Let's talk about that for a second. In a good estate plan, you'll provide for the possibility, not the eventuality, but the possibility that a child might be in a special needs situation. If she doesn't have a will, she can't provide for that. Included in my assets are a very special diamond sapphire ring. It's a family heirloom, but since I don't have any daughters, I intended to give this ring to my firstborn granddaughter. That's not going to happen because I don't have a will, right? And you could go on and think of all those other things that probably were in her head, but she just never got around to putting it on paper. She says, when my children, just skipping down, when my children reach age 18, they shall have full rights to withdraw and spend all the money that I have left to them in their shares of my estate. They may spend this money in any way they see fit, including but not limited to, and then it gives all those things that most 18-year-olds would like to spend their money on: motorcycles, sports cars, parties, 200 closest friends. No one will have the right to question my children about how they spend their money. Okay, this brings us to an important point. What is one of the components of a good will that is providing for children? We create a trust for the children, right? We make sure that instead of just giving them money at a young age, there's a trust there that provides the fiduciary to be the gatekeeper, to be the one who makes sure that we don't have these motorcycles or wild parties going on, at least in a controlled manner. They're supposed to be there to make sure that the money's used for what would parents typically expect their money to be used for? Health care. Education's a big one, right? Okay, exactly. And probably to start a business or maybe get them launched in a new home, all those kinds of things. Goes on and it says, should my husband remarry and also die without a will, his second wife will then be entitled to 1/2 of everything my husband owns, including the amount which he inherited from me. This is probably the one biggest motivator for people to go ahead and do an estate plan, is when they start thinking of, well, if I'm not around and my husband or my wife remarries, all that money that I was hoping was going to pass to my children, not a dime may reach them. It may very well go on to a second spouse if my own spouse passes away. Then it says, my husband's second wife shall not be bound to spend any part of the share of on my children's behalf, even if they need the money for health, education, and support. And then it goes on and talks about all the other things that are going to go wrong. Under personal representative, it says, I decline to exercise my right to name an executor. Many times people will say to me, I don't think I really need a will. You may find this in your drafting this coming weekend or at any time when you're serving in the clinic. Somebody will say, you know, somebody told me I need a will, but I really don't think I need one. And the best answer, I think, to that is you need one if for no other reason, because you need to name your executor. You need to pick the person who you feel you can trust, who will carry out your wishes. So if somebody's kind of tottering on the fence, that's the answer you want to give them. Yes?
I know a lot of people always say, well, I don't have anything, so I don't need a will. There's nothing to give away. And what the example I like to use is that it was an instance where this man who didn't have much, his brother ended up passing away after he passed away.
Mm-hmm.
And his brother left everything to him.
Mm.
And then, like, all his kids started fighting over who should get the money, because it was well over like $20 million. Wow. So it was like, everybody's like, no, well, I took care of that, or I did this, or I did that. And it was like,
Sure.
all, you know, they're fighting over the money, even though it's ridiculous. They could have just split it. But
Yeah.
I always say, you never know who's going to leave you something.
Very good example, Terry. And it makes a really good point. Life happens, and it doesn't always happen in a negative way. Sometimes something really good can happen, and you didn't foresee it. You didn't put anything down in writing. You don't have an executor who you could trust. You don't have a trust in place to make sure that the children all know what's going to happen and who's going to take care of those assets. So we're going to talk about drafting to avoid this problem. Yes, sir.
I was just going to add to that about having more than you think you know you have. I have a lawyer friend from Williamsport, and he always says, when I go, I hope it's a good tour. Because he knows that the value of his estate can be inflated. He wants his kids to get the money.
Yeah, that's right. That's good. That's good. Well, let's talk about the elements of a basic will. And you probably all know this, but let's just review them because it's good to be aware of what will we be putting into those documents that will be helping people draft. Okay, we already talked about one, which is the executor, the person who will carry out our wishes. I already alluded to the fact that we want to have at least one backup, and probably it'd be good to have a couple of backup or contingent executors. Fiduciaries include also guardians. So we mentioned guardians a moment ago. We'll want to make sure that, that they are named. And then we have to make sure that we make it clear if we name a couple, and this frequently happens, if I name Mr. and Mrs. X, do I want Mr. X if Mrs. X isn't in the picture for some reason? Or do I want Mrs.? Or do I just want to skip over them and go to Mr. and Mrs. Y? So make sure that the people who are giving you the information think through all of those different contingencies. What's another component to a good will? Tell me what you think needs to be in a valid will. This is going back to law school, right? One of the things that needs to be signed, okay, needs to be witnessed, right? Witnessed by, in Pennsylvania, at least 2 witnesses. There should be, it's not legally required, but there should be a notarization because it will make it much easier to probate the will, okay, right? And our friends at the Register of Wills office will appreciate that, that's right. We also need to make sure that it clearly identifies that it is the testator or testatrix's will, so it says their name and it identifies where they're from and those sorts of things. By the way, when it's identifying the executors, we want to make sure we identify them with an address or, as we said, maybe another identifying feature so that it's easy to track them down if they've moved. Okay, other things you can think of, yes?
If they were ever legally married, how did the legal marriage end, if at all?
Good. May want to recite the fact that I am divorced from Mrs. So-and-so, and we were divorced on such a date. You might even give a reference to a divorce decree or something like that. Always want to identify the family so that it's clear you knew who it was that was in your family and that you as the testator have an understanding of who are the natural objects of your bounty, as they say in the law books. Okay, other things you can think of. I think we've hit on most of the main ones. All right, yes?
Can you put yourself down as executor to probate the estate? I've heard lawyers doing that, they put their own
Okay.
name, and that way when the people, after the funeral, are trying to figure out what to do, they're like, I don't know how to read this thing. Oh, let's call this number at the top of the letterhead.
Right.
It says for questions about this will.
Yeah, call so-and-so. I'll give you a couple of answers to that. One is, the law doesn't prohibit it by any means, and there are many attorneys who will, in fact, put their name in as executor. I think that, personally, it's a conflict of interest to do that because it's sort of like you're forcing your future legal services on a client or someone who isn't even in your client group, because this could be like a family member that you're basically saying, I'm going to serve as the executor. So instead, I think it's good to make sure that there's some kind of identifying information on every original and copy of the document. So for example, when our firm will send out copies, we'll make sure that there's a document strip or a document backer that has the name of the firm and how to contact the firm, so that when people are scratching their heads and saying, what do? They'll know where to go and who to contact.
But for questions about this will, call this
Sure.
number for free.
You could even make a stamp like that, right? Maybe put it on, this is a copy of the original. Original is located at such and such a firm. For questions, call this number.
That's a
Sure.
good one. The
Could do
original
that.
is located at such and such firm.
Right, yeah. A lot of firms will do that. Did you have something you wanted to say? Okay, all right, good. That's all right. We talked about procrastinators' wills. All right, other documents that are part of a good estate plan include, and we talked about these a moment ago, a durable financial power of attorney, a living will, or it's frequently referred to as an advance directive for health care, a durable medical power of attorney, and a living trust sometimes. Okay, and we'll talk about trusts in a moment. Anything else you can think of that would be good to see in an estate plan, a basic estate plan? All right. Yes, John.
Well, it's more informal, but maybe a explaining your wishes.
Good idea. You might want to write a letter to any of the fiduciaries who are named. The executor is going to have a big job and a very concentrated period of time, usually 9 to 12 months, and they'll have lots of questions. I wonder what Mr. X really wanted. I see what it says in the will, but I only have some basic information here. He named me, what should I do? So you could put a letter together that says, these are the things I'd like to do. The only caution there is you have to make sure that the person who's writing that letter is avoiding trying to supersede what the will says. So they have to give guidelines, but always say this is governed by the will. Okay, good. Same thing for guardians. A lot of times when people have special needs children, they'll put together an entire life plan for that child, and they'll say, this is what I expect, this is what I'd like you to try to implement, how to make the transition a little bit smoother. Also for trustees who have a longer term role, you'd want to tell them, what is my goal for that money? Again, most of the time it'll be education, but there may be other things too. Yes, John?
Yeah, there may be things which don't go into the estate, life insurance or IRAs, there could be named beneficiaries, and finding those life insurance policies and IRAs can be quite challenging.
Yes. Yeah, good point. So one of the things that can be an important part of a good estate planning interview is to say, not only do I want to talk about the things that you own, that you can touch and that you frequently think about as yours, but what are the things that are intangibles or things that perhaps won't even pass through the will as part of your probate estate, but nevertheless will be under consideration by your executor, such as a life insurance policy. Another example would be 401k plan or an IRA. Many of these, all of those that we just named are non-probate assets. They have beneficiary designations included, and so they'll pass outside of the will and yet nevertheless will go to beneficiaries. Many times people will think, if you haven't talked to them about it in the interview, they'll think that they've left everything, including those non-probate assets, through their will. And they're very happy that they've divided it up among all their children, except they gave an extra percentage, extra larger percentage to one child because of their particular financial needs. And then they realize, when you talk to them, because you should do this, that they really need to make sure that those same beneficiary designations are included in their life insurance policy, their IRA, 401k, whatever it might be. Okay, very good point. One of the main things that is overlooked, and it's easy to do this, in that initial client discussion is titling of assets. Many times people will just assume that they own something and then they find out that they don't. Or they find out, yeah, actually I have it owned with my child or my parent or my second cousin. You know, we just ended up owning this together. And so many times it's important to talk about how are assets titled in that initial interview. I gave you, many of you have this estate planning questionnaire. It's just a piece of a questionnaire that I typically hand out to clients. And the only reason I gave it to you is just so that you could see some of the types of facts that you'll want to gather when you're sitting down for that initial meeting. Now, if you're meeting in a clinic situation, it's going to be a little bit of a different experience because not only are you going to be gathering facts, but you're going to be applying them to the document template, and we'll go over that in a few moments. So you're going to be doing a lot of things all at once. It's going to take a little getting used to. You'll need to get a sense of what are the things that I need to make sure that I ask. And you may even want to try to use a sheet like this or something similar that will get some of those facts down on paper so that when the person comes in to see you, they'll already have thought through, okay, well, I know who I am, who my spouse is. Hopefully they know that. They know who their children are and what their birth dates are. They'll have some of this basic information down. And maybe they've even thought about who would my fiduciaries be? Who would I like to name as power of attorney? Who would I like to name as my executor and guardian and those kinds of things? And if they look down through the sheet, they'll also see that they have a place where they can name a contingent fiduciary. And so you'll want to make sure that they're thinking through that either before they come to see you. I think probably one of the best ways, best approaches to take would be to start off by saying one of the most important components of your estate plan is not the document that we're going to create today, but rather it's the people who are going to execute or carry out your wishes. So we need to make sure that you pick the right people. If you're not ready to do that quite yet, maybe come back to the next clinic. But here, take this sheet with you and it'll help you think about it in between times. Or if you are ready, but you haven't really kind of put things in order, here's a sheet. Why don't you go out for a few minutes and I'll work with this other person and then we'll bring you back in. So it's kind of a good way to keep things moving along. Having a sheet like that can be very helpful. Obviously, you're going to be asking for a lot of information from the person. You're going to need to make sure that you're doing that in a way that gets to all the pieces of information in an orderly and timely fashion. Okay, before we move on to any mistakes, any questions to this point? Yes?
I have a couple questions.
Go ahead.
One for the, memorandum that you have people sort of make up the, well, what I do with my clients is I tell them, if you want specific things to go to specific people, put it in a separate memorandum, because then you can change it around later.
Good idea,
And
sure.
deal with it if you need to.
Yes.
Here's my question, and what I tell them is put the memorandum with your original will in your safe deposit box.
Okay.
And leave it there.
Okay.
If you want to change it, and then the will can stay the same, you don't have to change the entire will.
Good, good.
My question is for the memorandum itself, should they be getting that notarized or?
Very good question. In fact, what I typically suggest to my clients is let's include in the will a reference to a separate memorandum that I may create. And if I do, it will be given the same weight as my will. Since it's going to be given the same weight, I tell them you need to execute it with the same testamentary formalities. And therefore, yes, 2 witnesses and a notary too. Yeah, all of that. And what I usually tell them is, and if you're in a clinic situation, you might even say this, if you're going to create a list like that, come back to the next clinic with the list and we'll make it official. We'll get it witnessed and notarized so that it becomes just as official. Otherwise, you have the beginning of World War III. You have a list and everybody says, oh, I don't think that's his writing, or I'm not sure he really meant that diamond ring, that kind of thing. So what you can also do if the list comes back in to be signed and formalized is also kind of inspect the descriptions that are included, maybe help with getting details included. But yes, that's a really good point, and I think it's good to build that kind of a document in because, again, it adds to the flexibility of the estate plan, right?
Now, I have another practical question.
Right.
Because like I said, I tell them to put it in the safe deposit box, but then how do they get in the safe deposit box after they pass?
Okay.
Or the executor?
Right, that's a very good question. And so the rules that banks have are that when someone passes away, unless their spouse is surviving, the box that they put documents into typically is going to be frozen, okay, until the fiduciary, the executor, is appointed and they can come in and show that they've been authorized to go into the box. However, institutions will allow a person who thinks that there might be a will or a document that's like a will with a list of specific items in it, to enter the box just for that purpose. So you are able to get around that general freeze on the box for just that purpose. Now, that also brings up a good point, and I'm glad we're talking about this. If you're advising the people who you're giving a copy of their will to put it into a safe deposit box, I usually tell them, and make a second copy and put it with your important papers wherever they may be in your home, and let somebody know where that is. Some people are really secretive. They don't like the idea of sharing that information, and so you may say to them, okay, figure out a way so that you can tell someone, if I pass away, then you need to go into my freezer, or you need to go into this container, or this file, or whatever. Don't tell them what's there, just say that's where you need to go, okay?
Now, this raises another follow-up question.
Sure.
If they're allowed to go in and just to see if there's a will, how do they get that will to register?
They're allowed to take it out as well.
Oh,
Yeah, they can take the will with them, but they can't take anything else. Everything else has to stay in the box, gets resealed. They go to the Register of Wills, and that's the website we have up on the screen here now, the Philadelphia Register of Wills office. And basically what what they say to them is, okay, here's the will, here's a death certificate, petition for probate. Please appoint me to serve as the executor of this estate. And then as soon as they get a short certificate, they can take it to the bank and show that they have authority. Okay. So just wanted to make sure you were familiar with this website. If a client comes in and they are a resident of Philadelphia and they want to know a little bit more about a particular question, or they want to know just where the website is, you can show it to them. There's some significant resources here. They talk about, and I'll even show you they have something about wills, what a will is, estates, inheritance tax. It's just a good resource for somebody who you may not have enough time to cover all these topics with them, especially in a clinic setting where you're trying to get that document together and sign, witnessed, and notarized. You can at least say, if you have more questions, this is a good resource for you. That's assuming they have access to the internet, but if they do and can look at it, then if they have questions after that, they could call the Register of Wills, right? Or they could call the clinic and say, I have a follow-up question, whatever it might be. Okay, let's take a look now at the blank will template, which is available on the CLCP, Christian Legal Clinics of Philadelphia website. You can access this page. This gives instructions about the will for someone who might be working with you, but you want to print these instructions out and hand them to them with the will that's created. And then it begins, as you can see on the screen, begins with personal information. We've talked about how these things need to be included, the name and perhaps their address, not just the county. You might give their actual street address. People a lot of times ask me, well, if I put my street address in and I move, doesn't that invalidate the will? No, it doesn't. It just is identifying where they were living at the time that was created. The next piece of important information is marital status. If they're married, put in the name of their spouse. If they're not married, it's important to modify this paragraph and say, I am unmarried, or I was married before, we mentioned this before, and yet I was divorced on such and such a date. Many times they won't remember the date. They might remember the year, though, and you can put that in. They might remember the county as well. Then it identifies the children. I think it's a good idea to include the children's birth dates, because then we know for sure that John Q. Smith is the right John Q. Smith, because that's a common name. Okay, then it talks about disposing of property. And this brings us to the first place where we talk about specific bequests. This is a place where you could include a reference to a list to be separately prepared. You'd have to add a sentence that says something to that effect. If you're not comfortable with that, you can say, okay, let's put the specific bequests right here in this section of the will, and understand that if they change their mind about one of those specific bequests, they're going to have to make a change to their will as well. Any questions up to this point? I'm going to zip through those first few paragraphs. Then it says, you see at the top of the screen, I leave my residuary estate, so that'd be everything else other than those specific items, to my, put the name of the spouse again, and then, and of course, if you're preparing wills for a husband and wife, you're going to be doing the exact same thing in both of the documents, naming their spouse in these contexts, and then saying if they're not living, they don't survive me, I leave my residuary estate in equal shares to my children, and you can put in the names of the children there. What else might you want to do? This is an alternative here, right? You might want to say, if my children aren't living, then I leave my residuary estate to a charity. That's something that people will sometimes do. Or they'll say, if my children aren't living, then I leave it to my intestate heirs, whoever might be identified in the intestate statutes of the state in which I die. The problem with that, of course, is that you don't know what state they're going to pass away in, and there may be a provision that actually leaves it to somebody who they really wouldn't want to give it to. Or they might really have a specific person in mind, and so the preference there would actually be to name either a class of beneficiaries, maybe brothers and sisters, or sometimes they'll just say all of my nieces and nephews, that sort of thing. Let's go back up to the children. Yes, John.
Where, if at all, in this section might you include the words per stirpes or per capita?
Right. You'll see right on the screen towards the top it says to my children, comma, per stirpes. It's in italics there, and so that would be the place. If for some reason someone wanted to put a per capita distribution in, you could change that. However, I would do it advisedly because most people don't want that. It's very unusual for someone to say, I want to make a per capita distribution. If you needed to explain it to them, this would be the point in time to describe that to them. If they would like to create a trust for their children, this document isn't set up to do that. It's much more suited to someone who has adult children who would be comfortable with giving those adult children all of their share of the assets all at once. If, however, they are choosing to do a trust for their children, then my recommendation would be either to tell them, we'll work a document up for you, and the next time the clinic is meeting, you can come in and I'll go over it with you, and you explain the concept of a trust to them, or you can explain to them the consequences of not creating a trust and then help them decide whether that makes sense or not. That all makes sense? Okay. Any questions? In addition to that, we talked about backup provisions. There are some places to indicate all property left in this will to, and then it identifies the minor children, shall be given to a custodian. So that's an alternative to creating a trust in a separate document. You could use this provision to say, we'll use the Pennsylvania Uniform Transfers to Minors Act to be held until they reach age, in here it says 21. And so you need to identify or explain to the people, there is a potential problem with this in that very age when they're going to be receiving the distribution is a time when they might be likely to, again, use it for motorcycles, cars, parties, whatever it might be. And again, I wouldn't say you need to tell people you must create a trust. You just need to explain to them that if they're using this provision, that's a possibility that could play out. Personal guardian, it says if at the time of their death there is a need for a guardian, and that would mean that both of the spouses have passed away, then we're going to name so-and-so to serve jointly. It's set up to be a provision where both a husband and wife will serve jointly. Occasionally people will want to name two different siblings. What would you think about that? How would you recommend someone make that decision? Do you think it's a good idea for them to name two siblings to work together as guardians? Some of you are saying no. Why is that? What's the problem with setting that up that way?
Too many cooks in the kitchen.
Okay, sure. Well, if for no other reason, if the siblings live in New York and California, where are the children going to live? It's one place or the other probably, or then there's going to be a crazy arrangement where they have to go back and forth. So naming two people, the presumption would be it would be a husband and wife. And as we said before, you may want to indicate if one of them isn't living, do we still stay with the surviving solo parent, or do we skip to another couple that you'd want to name? So those are things to consider as you're working through that part 7 of the will. Part 8 talks about property guardian, into the idea of a trustee. And so you're saying, okay, who is it that we're going to name to hold on to the assets that are going to pass for and on behalf of some of the children? In this case, they identify it as minor children. Okay, and that might or might not be the same person as the guardian we identified in Part 7, who is going to be acting as a parent. This property guardian or guardian of the estate is going to be very similar to a trustee. They'll have that fiduciary level of duty, but it doesn't identify them as a trustee. It doesn't create a trust per se, and yet there is a trust type relationship being created here. Any questions up to this point? Okay. Next is the executor. I name the executor, and it gives the place to fill in the name. It also gives a place to put in an alternate executor. Again, it's probably not a bad idea to add one more sentence in that says if both of those people can't serve, then alternate executor number 2 could serve at this point. It gives a standard set of powers for the executor, and there's 6 of them there. Identifies the executor being able to pay debts and to pay any taxes. One of the other significant problems for people in thinking about their estate plan is we talked about how titling can be a problem. Taxes, another T, is an issue for people because they a lot of times don't take taxes into consideration. It's not likely that the people who would be coming to the clinic would be having a need for a sophisticated tax avoidance scheme, but you'd want to make sure that you identify for them that Pennsylvania has an inheritance tax and how the tax works, the tax rate for lineal descendants, whereas descendants would be 4.5%, the tax for more distant relatives, 12%, for friends, 15%. And so you'd want to make sure that they were aware that there's going to be a tax to be paid, because sometimes people will only have illiquid assets. They'll have a house and maybe one other asset that's hard to liquidate. And so you want to make sure that they're aware that something is going to have to be used to pay. They may be considering buying life insurance for just that reason, or they may be thinking about other things. Yes?
Okay, since we're talking about taxes, I know also there's a discount too if you pay certain, just to tell them that if they want to save money too.
Right. Good point, Terry. It's good for people who are making their wills to know that, because they may have a conversation with their executor. When they say, I'd like you to be my executor, they can also say, make sure you don't waste any time after I pass away, because there's only a 90-day window within which the inheritance tax can be paid at a discount. After that, it has to be paid within 9 months at the full rate. That's right. Good. Okay.
Can I
yes,
ask a question about
absolutely.
the tax clause? So what's the intent here for, if you have a client that comes and they have an IRA that goes to their son, or they've made gifts within a year of death that are subject to inheritance taxes, the intent that the probate estate will pay those taxes, or that the beneficiaries are responsible for the taxes here?
Right, very good question. And the answer is that the document is drawn up in such a way that it says all estate taxes assessed against the property in my estate or against my beneficiaries be paid in the manner provided by the laws of Pennsylvania. We can be more specific than that. We could say, to the extent that there are assets that are not part of my estate, then those assets would bear their share of any inheritance taxes. That could be a sentence that would be added in at this point. And so if the person identifies the fact, and many people at this point in time do have IRAs, many people have life insurance. Now, life insurance, fortunately, in Pennsylvania is not subject to inheritance tax. But we definitely would want to identify that in this particular clause. Yes?
Since you brought that up, I had a question. I don't know if it's too off topic from what we're saying, but
If it is, we'll talk about it afterwards. Go ahead, Terry.
If you have a life insurance policy that doesn't have a beneficiary and then it becomes a part of the estate, is it still non-taxable, or does it become a taxable asset?
Still not subject to the inheritance tax, I believe. Yeah. So that's a good thing, because otherwise, if it goes through the estate, it automatically is subject to that tax. Right. Okay. There's a no contest provision in here. This is a kind of a safety clause that would protect, we hope, from someone challenging the will if they're not left a full equal share. Or sometimes people will say, well, I'm entitled to everything, so I'm going to challenge whatever's in there. Understand that no contest clauses are only as good as the value that the person's giving up. So if you leave nothing to son A, he's probably going to contest that, or he very likely will consider contesting it because he has nothing to lose. Whereas here it says that any share that or interest that they may have would be lost. So you want to talk to people. If you're really thinking of doing that, you may want to put something in as a distribution that would give them a stake in not trying to contest. Also, it's important to be clear that if a spouse is considering contesting because you've left them out of your will, they have the right to elect against the will, and that is going to supersede this no contest clause. Okay, severability just says if there's anything that seems to be invalid based on the law of the state in which it's being probated, all the rest of the will would still remain in effect. Then there's a place for signature. As we've already said, make sure that the person dates the will in this spot where it says signature. They're going to be signing on the signature line. 2 witnesses need to be present at the time, and they need to be signing their names as first and second witness, giving their addresses, clearly printing their names so that if we did need to contact them, we'd be able to do that. And then it talks about the self-proving affidavit, there are instructions for notarizing, and there's the acknowledgement. And we've come to the end of the form itself. As I said at the beginning, there are some instructions that can be printed out to be handed out with the document, and then instructions in the form of a letter to an executor, the idea that John had suggested before. You can be a lot more detailed than this. This is just kind of the bare bones beginning of one. But it's good to suggest to people, okay, here's the idea. You can take off on that and add to it. Okay. Let's see now. Going back to, I think we'll go back to some common estate planning myths or mistakes, and then we'll come back to the powers of attorney if we have a couple minutes to touch on them. So some mistakes that we can make in in setting up the estate plan would be things like dying without a will. We've already talked about how bad that could be for a procrastinator. Dying with an incomplete will. This is something that's could be overlooked, and what you want to do is make sure that every eventuality, every contingency is covered in a will. If people say, I just want to leave everything to my spouse, I'm not worried about anybody else. The answer is, yeah, but you have children, so let's make sure that we name them too. If they've already taken care of their children, push them to go to that next level. But what if none of the children are around? Do they have children? Well, we should probably provide for per stirpes distribution to the grandchildren. Or if nobody's living in the immediate family, what's the next level? How do we want to distribute assets? Okay, joint tenancy with a non-spouse. Many times people will set up accounts at a bank for a convenience factor, but they're also thinking, well, if I pass away, then I don't need a will because it'll just pass because it's jointly owned. I named all of my children as my co-owners. Doesn't that take care of it? I empty the cookie jar, get it out of my own ownership, or make myself only a partial owner, and it's just going to pass. Does that solve all of their problems? No, there's a mistake here being made. One is assuming that you can put joint tenancy on all of your assets, which doesn't always work. Another problem is that sometimes, although you may avoid probate, there will still be a tax on the asset. At least a portion of the asset will be valued and taxed. And also, sometimes it's giving to that person or those people the ability to withdraw the asset from the bank or take it and move it to somewhere else, and you lose control because of a concern about taxes. Not providing for special needs beneficiaries. Unfortunately, if you put an asset into a trust or make an outright distribution to a special needs beneficiary, you can make them immediately ineligible for public assistance. And so rather than doing that, you'd want to talk to them about coming back to the clinic. Okay, if this is a situation that's a concern for them, you're not going to deal with that in a simple will. It's going to be something you'll need to modify and add some provisions that are going to allow for a special needs trust to be created. Losing or destroying original documents. We just talked about how important it is to put them in a safe place, identify that place, make sure everybody knows where that is. If for some reason there's an intent that is ambiguous in a document, you say, I give my, my coin collection. I give my coin collection to son A, but if he's not around, then I give it to all of my other children. And there are no other children. Or it's not clear what the coin collection consists of, or this or that. There are all kinds of things that could be wrong with your description. There's a rule of evidence that says that if the person is deceased, if they're a dead man, then they can't testify through other people's testimony. You can't say, well, he told me this, or I have that list, right, and it's not really clear, but it's okay because I can tell you what it means. Now that's not going to be allowed. So that's a problem that can result. Okay, we're at the conclusion stage. We can take a moment, if you'd like, and take a look at the power of attorney form. Would you like to do that for just a minute so we make sure that we cover that too? But before we get to the power of attorney form, I just want to make sure, are there any questions up to this point? Anything we need to go over? Okay, so let's just go to the power of attorney form. Yes, John?
The question may or may not be appropriate now, so please dismiss it if it's not.
Okay.
Clients here from Christian Legal Clinic of Philadelphia, a situation come up frequently is the real estate of about $50,000 is in the testator's name.
Mm-hmm.
There may or may not be a will, but they receive services from the state of Pennsylvania, and Pennsylvania waives any charge. So they're receiving these free services, but Pennsylvania...
Quote unquote free, right? Yeah.
Pardon?
Quote unquote free, yeah.
Yeah, but Pennsylvania they have to sign something saying that they understand that Pennsylvania, after the person passes away, has a right to claim against the estate.
Mm-hmm.
So the lien is put on the real estate. And the lien can be for $200,000 or over 10 years, someone can receive so many services
Mm-hmm.
that there's a claim potentially by the state against the real estate for $200,000. It's valued at $50,000 or so.
Mm-hmm. Mm-hmm.
Now, there's a hardship waiver, I understand, that if a child of the deceased person lived with them for over 2 years, then they could qualify and all of this claim by Pennsylvania would be forgiven. So this has come up several times here with clients of our
Interesting.
particular clinics that I've seen.
Mm-hmm.
And people are struggling with this issue. So
Right.
what should they do? Because they can qualify for the hardship waiver so that their mother or father can receive all these services from Pennsylvania free.
Mm-hmm.
That's more advantageous. They'd like to keep ownership of the real estate as a family if they can.
Mm-hmm.
So what do they do?
Yeah, and it's a good question because it arises, as you said, in the clinic context frequently. Somebody else have something on that point? Okay. And it's not always the same answer for every family because in some situations, pass the asset to the next generation, allow them to take care and possibly qualify for the hardship waiver. In some cases, it doesn't make sense, and it makes it's going to be a problem for them to make that transfer. Sometimes they'll have a significant capital gain built up, and actually it makes sense for them to hold on to the asset. So you may need to talk through those issues with them as well. But it's very important to be aware of the Medicaid lien issues that could be facing somebody, especially if their main asset is their real estate, their home that they live in. Okay, let's take a look at this next form, which is a durable power of attorney for financial management. And this is a document that begins with a long notice, making sure that the person understands what they're doing, that they're giving over significant powers. The principal is the person creating the document. So you'll fill in their information at the beginning. I'll just go back up. And then their name, they're appointing. The agent is the person who they're naming to act on their behalf. And then they can name a successor agent. And that's where they could identify even more than one successor if necessary to make sure that they have that person. Then it gives the opportunity to put initials in each of these different blanks. And the idea is that they're going to consider carefully which of these powers they'd like to give. In some cases, it will be all of the powers. In many cases, it will be. But sometimes they won't want to initial a specific item because they don't feel comfortable with their agent doing that for any reason. Then it goes on and it talks about the obligations of the agent and nominating them to serve as conservator or guardian for their estate and other types of powers that are granted. And what you're doing is giving them the ability to, again, create a script in case they were to become incapacitated for who is it that's going to serve on their behalf. Taking you down through the rest of the document, there are lots of provisions, lots of powers given here. Probably something that it would be helpful for them to get a chance to read through it. So you may want to give them that opportunity in the clinic setting and then sign a little bit later on in that same time frame, or maybe have them come back to the next clinic after they've had a chance to look at a draft. And this is just explaining what all of those different paragraphs were at the beginning, that they could put their initials. It gives all the detailed explanations of what they're giving the power for. And then, of course, there's just in the same way as with the will, the place to sign, have the witnesses sign and give their addresses, and the opportunity for a notary to notarize the document. We're going to have notaries here, I believe, Saturday, and each time the clinic is offered, there'll be a notary available to do that. The agent themselves has to sign, indicating that they know they're being appointed and that authority is being delegated to them. Any questions with regard to the power of attorney document? And the other one that we want to look at is a healthcare power of attorney. In this document, you're saying, and it's like an advance directive for healthcare. It's giving instructions, saying you want to make sure that you carefully consider this, make sure the agent knows that they're being appointed. It talks about putting X's or checks in a specific place to indicate your wishes. So in this document, you're going to be appointing an agent. You put the name of the person, the relationship of the agent to them, and if they can't serve, the alternate agent. And again, you may want to name a second alternate in this document. It gives contact information for the agent so that if this person is incapacitated, they're in a terminal state, and the agent needs to be contacted, that's the place where all that contact information can be included. You may want to put phone numbers, cell numbers would be a good idea, especially. Gives the agent authority by initialing this one paragraph to authorize the agent to make decisions to withhold or withdraw life-sustaining treatment. And the next is to withhold or withdraw artificially administered nutrition and hydration. So those two specific choices need to be made as to whether they want to give that authority or not. It becomes effective when it's determined that they're incapable of making their own decisions for themselves. And then it goes on, and it talks about the Pennsylvania law will be applying to this document. Gives some definitions of the different types of terms that we've been talking about, and then there's a place again for signature, 2 witnesses to sign, similar to what we had talked about before. Now, as you can tell, this is a document that covers only life termination decision making. There is an alternative that you can offer to the clients, and that would be to do what we talked about earlier in the seminar, which is to do a healthcare power of attorney and a financial power of attorney, in which you're separating those two functions out. If you do a healthcare power of attorney, it would include all of these types of decisions, life termination, but it would also include just general medical decision making. And some people prefer to do that because they feel they're giving more control to their agent and less to doctors. But that's, for different people see it different ways. That's just something that'd be good to talk about with them. Yes?
Couple questions. For just the regular financial power of attorney, one thing I usually recommend to people if they're healthy is to do a springing power of attorney.
Mm-hmm.
And one question that always...
And just so we clarify, a springing power, by that you're meaning that it only comes into effect if they become incapacitated, yes, and somebody has to certify that they are, right?
Yes.
Yep, okay.
And that's the question that the client always asks is, well, how do you determine if I'm incapacitated?
Mm-hmm.
And I never have a good answer.
Okay.
What I tell them is 99% of the time it's going to be pretty obvious.
Mm-hmm.
But
okay.
That's usually not satisfying.
Yeah, and they've probably known of someone who was kind of going a downhill slope, but they're not quite down to the bottom of the hill yet. And so I think a good answer would be to say if you are setting it up as a springing power, it will require a doctor to sign. So they're going to have to put their name on a line that says, I'm certifying, I'm putting my medical reputation on the line here and saying, I really have confirmed that this person is incapacitated. Now, you could also say to them, if there's a disagreement about it and nobody can agree and there's not a doctor who's willing to sign, their alternative is they're going to go through a guardianship proceeding. And so many times people will say, well, I'd rather have a power of attorney in place, and even if there were to be a disagreement, at least maybe we could avoid a guardianship. That's what a lot of people will say. But yes, creating a springing power is not a bad idea, especially if they're concerned that maybe their power of attorney would step in too soon.
Yeah, that's
Right.
usually the concern.
Yep, makes sense. Other questions? Okay. I think we've covered all we needed to for today, and we're all done. Thank you for this opportunity to help kind of walk through the drafting process and kind of an overview of estate planning in general. If you have any particular questions after we're all done, I'll be glad to stick around and we'll talk about them. Okay, thanks. Thank you. And this is